protocols having been established, I respectfully wish to adopt same and to add the Deputy High Commissioner of the British High Commission. Distinguished ladies and gentlemen, sexual violence is committed against women, against men, and against children. It is a criminal offense, and it is also a violation of human rights. Reports have shown that there is a high incidence of rape within the Caribbean, and Guyana has signed on and ratified a number of international instruments. For example, the Convention on the Elimination of All Forms of Violence and Discrimination Against Women, CEDAW, and the Convention on the Rights of the Child. And we have in turn given legislative effect to those pieces of international documents in our Constitution. And so the Constitution provides for appropriate legislative, administrative, social, and educational measure to protect child, women, and others from physical, mental, and sexual violence. And chiefly among the pieces of legislation that Guyana has passed is the Sexual Offences Act of 2010. Section 44 of that act provides for the establishment of a sexual offences court. And I'm happy to say that Guyana has established the first such court within the Caribbean region. When partnering with Unicef, we were able to open the doors in November 2017 of such an institution. Former Chancellor of Judiciary Desiree Bernard said, and I quote, that sexual violence preys on and affects one's emotions and leaves behind the deepest psychological scars. It is ubiquitous in that it can be perpetrated anywhere on any victim, regardless of that person's age, gender, or social training. The youngest infant is equally liable to be sexually assaulted, as well as the oldest adult, either in the privacy of their home, in the workplace, or in dark, secretive places away from the public view. Sexual violence, we know, can have long-lasting impact or effect on the victims. It can be emotional, psychological, physical, you name it. And the perpetrator, more often than not, destroys or damages the life or well-being, the social well-being or the emotional state of the victim. We know only too well that when the matter is reported and investigated and proceeds to trial, there's even more trauma if the case is not handled properly or if we are insensitive to the needs of the victims. This in itself can cause secondary trauma or re-victimization. And this may cause the victim to withdraw from the court system. They may refuse to give their statement to the police, or they may stay away or decide not to face the offender and the jury. They may think it's an hostile environment, and indeed it could be at times, having to face the police, the prosecutor, the state lawyer, the defense counsel, and even the judge asking questions about the incident. How did it take place? When and where? Who was there? Where was he? Where were you? What was the victim wearing? Did you make any noise? Did you scream? Was anyone around? What is your sexual history? Did you make a complaint? And if so, how long after? Did you know the offender? How did you react? Etc., etc., etc. And these questions could have an impact on the victim. And to prompt it, or to add to that too, the victim will be told, or could be told in cross-examination, that their story is a fabrication and that they want to fleece money out of the offender, or the charges are trumped up and they're now coming with this story, or maybe they had a relationship with the offender and because they were caught, they're crying rape. Indeed, this could be a harrowing experience, it could be traumatic, it could even be an ordeal. And we saw from that a very low conviction rate, a very low report of sexual violence cases. The Compound Act cases took a long time to go through the court system, and therefore we realized that specialized intervention on the part of all stakeholders was needed. And this bore fruit with the advent of the Sexual Offences Act of 2010 and the Sexual Offences Court in 2017. We're happy to say that after the first court was established in Georgetown, in this year, April this year, another court was established in Berbice, and in a short space of time, together again with the help of Unicef and the British High Commission, another court will be established in Surrey. But prior to the new Sexual Offences Act and court and the Sexual Offences Court, victims went through this ordeal having to face the cold confines of the police station to make their report. And then from the police station they were sent to the austere environment of the Magistrates Court and the High Court to be brought to question and even humiliated before 12 strangers who are called jurors, defense counsel, prosecutors or state lawyers, and even members of the public. Thankfully, the Criminal Law Offences Act, which was the old regime governing rape cases, made provision for cases involving sexual violence to be held in private or in camera, and for the name of the victim to be withheld from reporting in the press. But that by itself is not sufficient. The specialized court, to our mind, was more important because it is equipped with necessary measures to protect victims from having to face the accused person or other persons in court. There have been closed-circuit television, special measures room, and even waiting rooms and facilities for the victim to be comfortable when giving their evidence. We've also had training for staff by special psychologists, clinical psychologists, Dr. Diane Douglas from Trinidad and Dr. Khadijah Khan from the University of the West Indies. And the aim of the Sexual Offences Code then is to ensure that the environment is conducive to victims and that support services are offered. Model guidelines developed by the Juris Project out of Canada are utilized, and they are intended to provide internationally accepted best practices for the management of sexual offense cases. And they offer a rights-based approach to treatment of complainants and vulnerable witnesses who have been involved in sexual assault cases. And these guidelines ensure that victims are not re-victimized as they seek redress from the justice system. We also have what is called a paper committal system, so that the witness does not have to give their evidence twice. The committal is done based on the statements that the witness would have provided to the police. And this will tend to reduce and eliminate the secondary trauma to the victims and improve the case cycle time and the outcome of the cases. With those services, the benefits we can boast of: faster disposal rate of cases from the time the case is reported to the time of trial or disposition, increase in the amount of cases heard, increased conviction rate, and specialized services to victims. It is not often then that we can have an opportunity to have so many key players and stakeholders to be in a room and have an engaging conversation with professionals on an important topic as the one we're discussing today: interrogating sexual violence. That topic is very apt. This meeting is very timely, and all of us are involved. There's this book by a Nigerian author writing about Mr. Carter, late Martin Carter. It says all are involved, and indeed we are all involved in today's conversation. We have social workers, psychologists, prosecutors, defense lawyers, non-governmental organization representatives. We have the DPP, we have Unicef, Child Care and Protection Representative. We have the Chief Justice, we have members of the public, we have you, the audience. We have founders and CEO of Critical Response, directors of Citizens, and we have everyone here who is important. We need, as Dr. Reynolds said, to engage in this conversation. We know that with discussion, much fruit could come forth. The seed has been planted by University of Guyana with the stain and turrentine talks, and we know that with the discussion here, the harvest will be bountiful. I take this opportunity to wish you and everyone here a wonderful discourse today on interrogating sexual violence.